about the awareness gap among the citizens of the country. So that small gap is making a huge difference in our country. So yes, sir.
We have a famous proverb, Arive Guru, which is in Kannada. Information matters. Fortunately, in 2005, the then Congress government enacted a law called Right to Information Act 2005.
Yes.
Wherever I go, I keep telling this: action, reaction, interaction, overaction and non-action of the government can be questioned through right to information.
Yes.
But how to question? That is where we fail. Because your freedom of speech and expression, quality of freedom of speech and expression depends upon quality of information. If you do not, if you are not aware about what is happening, then how can you participate in the process? So the major issue here, lack of awareness. In that respect, Justice Nagmohan Das, in fact, he wrote a book, Samvidhana Odu, reading the Constitution. Somewhere we should try our level best to reach out all these important, and duties to the general public in their vernacular language. In that respect, media plays a very significant role. If media start, not only media, it may be social media and day-to-day, affairs where the general public, if they are going to provide all details, information through different sources and all. Because if you go to village, if you go to tribal areas and vulnerable sections of the society, they never care about what are their rights and duties. They need shelter, food. These they are struggling for that
Basic
only
amenities.
Basic amenities. Then if this is the state of affairs, then you have to think. And very importantly, what I suggest as a law professor, it is our bounden duty to bring awareness to all these vulnerable sections, downtrodden through their vernacular language.
Yes, sir.
Very simplest way we have to bring awareness. If that is being done, then you can expect their participation in the process. Yes.
Yes, sir. Thank you so much for this insight. Sir, are citizens participating meaningfully in the democratic process today? If not, what are the factors that are limiting effective democratic participation, sir?
See, that's what I told. Why citizens are not coming forward? So many reasons. So many reasons. Number one, as I told you, lack of information, lack of awareness, lack of employment, especially youths, poverty.
Yes.
As I told you, no one can become a patriot with an empty stomach. Is it not?
Yes, sir.
So, citizens are, if they, wherever I go, I say that during the time of election, if citizens elect a best government, then they can expect positively the constitutional benefits from the respective government. If elections are during the time of election, if people do not come and participate, very unfortunate to say that illiterates are better than literates when it comes to voting during the time of election. Many literates only, we literates only do not go and vote.
Yes.
We never go to the booth. And when we ask generally they speak, no, we don't like any party. If that is the case, let them go and vote for Nota. Nota is none of the above. None of the above. Nota, if it wins, taking 1 lakh, 2 lakh votes, then the party who selected the candidate for contesting the election, they will introspect and they start selecting the best candidate for next election. So somewhere citizens should participate effectively during the time of, not only during the time of election, but also to claim their benefits which are available in the constitution.
Yes, sir.
Yes.
It's a very sobering thought.
Yeah.
So the next question is, What is the current status of access to justice for vulnerable and marginalized communities in India?
See, access to justice is one of the basic rights guaranteed to the citizen under Article 21. Supreme Court in series of cases they interpreted access to justice. Access to justice is one of the important human rights. In fact, after 42nd Amendment, they added 39 capital A in 1978 when Moraji Desai government came into power. Sorry, during Indira Gandhi's government, through 42nd Amendment, they added this 39 capital A, and to give an effect to this amendment, Government of India enacted a law called Legal Service Authority Act 1987. Then for Legal Service Authority Act, when it came, it was a small ray of hopes to the vulnerable sections of the society to reach out to the court on behalf of them. National Legal Service Authority, State Legal Service Authority, District Legal Service, Taluk Legal Service, and some advocates, many advocates, they come forward to render pro bono service. But that is not enough to the country like India, because access to justice is the main issue. I keep telling, a society without state, state without constitution, constitution without fundamental right, fundamental right without Article 32, Article 32 without access to justice, the very object is going to be defeated. Very unfortunate to say, actually, Dr. B.R. Ambedkar, father of Indian Constitution and the chairman of drafting committee, he said he was not anticipated the day when he was just mentioning. He says, if you ask me which is the best article in the Constitution, I would say my answer is Article 32. Article 32 is the heart and soul of our Indian Constitution. Provides access to justice to all, irrespective of their background. Only few people cannot, but anyone, whether he may be labor or maybe farmer or anyone, senior citizens, they can approach Supreme Court directly. That is why he said Article 32 is the heart and soul of our Indian Constitution. But tell me, heart beats for whom? Heart beats for only elite classes like Shankari Prasad, Sajjan Singh, Golaknath, Keshavananda Bharati, who is having finance, who are very financially strong, they can approach to the Supreme Court. What about the Rajamma, Rangaya, who are staying in village? Forget about going to the Supreme Court. They cannot reach out even small taluk courts in their respective taluk. The reason is finance matters. Advocates who want to engage cases on behalf of them, very difficult to get them. And record wise only they cannot collect some records. Nowadays, lawyers are also busy. They forget about rendering pro bono service. Of course, if they accept, if they are ready to, I appreciate in this regard MC Mehta. He has done a wonderful job. Wonderful. He's a best friend of democracy who participated in the process and questioned the unreasonable actions of the government and got wonderful relief, where thereby he promoted, protected mother and mother. Similarly, how many MC Mehtas are there in the country like India? Of course, even if they are ready to provide, they need records and all. Records they don't have time. Then ultimately the vulnerable section. Of course, I'm not talking about. We always think about the percentage of elite class. What about the percentage of poor, the weaker sections of the society? Very high. And one thing I wanted to tell you in this respect, access to justice to the vulnerable, somewhere legal service authority should come forward. Of course, they have been doing, but effectively it has to be done. If for Supreme Court, even if they go and approach to district legal service authority, taluk legal service, if it is a case of a, if it is, if it is a case of violating any fundamental rights by the state, let them take. Of course, some in some, for example, D.K. Basu versus State of West Bengal, the best example. D.K. Basu was a judge of Calcutta High Court, and also he was a chairman of West Bengal Legal Service Authority, where he wrote a letter to the judge of Supreme Court regarding guidelines, how to, what should be the guidelines to arrest the individual by the police officer. That letter converted into writ petition, and in D.K. Basu versus State of West Bengal, they laid down the guidelines. Similarly, we need such activist judges and lawyers and even professors. If they really come forward, definitely they can help. They can be the best instruments for the vulnerable sections of the society, for enjoying the access to justice, the right to access to justice.
Yeah, so that is actually the reality for so many people.
Yes, yes, yes.
And the law exists, but it doesn't feel like it belongs to them
Belongs
actually.
to them. Because of so many reasons,
Yes,
as I mentioned.
yes.
Yes.
So can India truly be described as a substantive democracy, or the gaps between the constitutional rights or the ideals and the ground realities, does it have any relation or anything?
A good question. When it comes to democracy, I always say democracy demands participation, as I told you in the first. Now you tell me, are we in a true democratic world, especially country like India? The reason is, recently, Association for Democratic Rights, a committed NGO, in 2024 after election, they revealed some information, statistics. What is the statistics? Out of 545 Lok Sabha members, totally 545 plus 250, approximately 800 people in Lok Sabha and Rajya Sabha, they are our lawmakers.
Yes.
Right? 800, what is the percentage of crorepati's? In ADR, they collected all details. It is available under RTA, because when you want to contest in the election, you have to provide all details, your asset details and all. They gone through all these files. They revealed, they provided information. 92% of the members of parliamentarians are crorepati's. 502, 503.
That's huge.
In India, vulnerable sections, who? Farmers, laborers, scheduled caste, scheduled tribe, other backward class, women, children, person with disabilities, senior citizen, they in total constitute 90-95%. But their representation in parliament, even not less than 5. So-called elite, crorepati's percentage are very less. Crorepati's percentage are very less, but these 5%, less than 5% elite class representation in parliament is 95%. Are they really going to concentrate to bring some changes in education sector, health sector, food sector? Especially, we have to be independent. We should not be dependent to any other countries in terms of food, in terms of healthcare service, in terms of education service, in terms of anything. Even we are depending upon for other countries for fuel and all, right?
Yes.
When do we start to think independently? So when such being the case, if I am a crorepati, I never concentrate on the weaker sections of the society, upgrading government hospital into multi-speciality hospitals, upgrading government schools like Kendriya Vidyalayam type. Central government is doing wonderful job. Why not for state? What is happening? So the reason is now Darwin theory comes into picture. Those who have money power, muscle power, and intellectual power, whatever power they are. So who has to come forward to protect interest of these uh, weaker sections of the society? That we have to introspect. That we have to. There is a huge gap between haves and have-nots. If this is the case, we have to think 100 times: Are we in a democratic country? Got it?
Yes, sir.
Yes.
And I do have a doubt, sir.
Yeah.
Do you think this gap is being closed or is it widening? What do you think is happening in the current situation in our country?
It is widening.
Okay.
It is widening because, of course, if I want to speak positively, the downtrodden now they should come forward to know something, and education matters for everyone. In one family, one educated is there. One person, if they become educated, then in future they start helping so many, not only their own family members, but also their village people who are residing village surrounding them. So we need a value oriented education,
Yes.
not commercial oriented education. Dr. B.R. Ambedkar says, if you want to destroy the country, destroy the education system, then automatically country gets destroyed. So, what is my message is, we need a value-oriented education to the children.
Yes.
Today, because of artificial intelligence and because of this, of course, if you go to any education institution, they are providing wonderful infrastructure. Everything is effective. But somewhere, values and principles are vanishing
Yes.
because of commercial type of thinking. That we have to think and introspect.
Yes, sir. So, what do you think should be the role of academicians, judges, lawyers, and the law students who play in upholding and promoting constitutional values in the society, sir?
Beautiful, beautiful question. See, if all like judges, academician, advocates, law students, four wheels of chariot in legal education,
Yes.
how we can do best? You all have heard about judicial activism. Why not advocate activism? MC Mehta is advocate activism. Like academic activism. How to ensure academic activism? Academician can play a very significant role. I tell you one incident regarding Gram Nyayalaya Act. You asked about access to justice. Gram Nyayalaya Act was enacted in 2008 when Manmohan Singh was Prime Minister. Unfortunately, till today, that has not been implemented in many states, including Karnataka. The objectives of the act, when the litigants cannot go to the court, let court go to those type of litigants.
Yes.
To help these vulnerable sections of the society. So almost 1.5 decade they are not yet implemented. Recently, I wrote an article just 6 months, 1 year back in Kannada, wherein famous Kannada newspaper, state newspaper, Rajavani, where I wrote my article in Kannada deliberately, vernacular language. The title of the article, ಗ್ರಾಮ ನ್ಯಾಯಾಲಯಗಳು ಗ್ರಾಮಗಳಿಗೆ ಹೋಗಲೇ ಇಲ್ಲ. Village courts have not reached village. The act is there in the white paper. Why Karnataka state did not come forward to implement in truth? Because this law was enacted by the then Congress government. Now Congress government is ruling. I hope the present law minister H.K. Patil Saab may implement this. That came in newspaper. Immediately, our law minister H.K. Patil, sir, in fact, he called press and immediately he told this government is committed to establish 100 Gram Nyayalayas. and within 15 days that was approved in the cabinet and prepared rules regulation. Now it is before High Court. Once if it is ready, then definitely all under Gamanayala start working in the Karnataka state. That is the beauty of academic act. One article published in Kannada which reached the law minister and announced, that means it is a, even academicians should come forward.
Yes, sir.
National law schools, whichever the schools, we have to introspect what we are doing for the society. Our duty is not only to train the student, but also we have to think about society. How best we can help the society we can do. Judges, lawyers, because see in Keshavananda Bharati's case, Nani Palkiwala and H.M. Shirvai, the stalwarts who argued the matter very systematic way, excellent way. The result is the judiciary brought out the best principle called doctrine of basic.
Absolutely, sir.
It is the long struggle product. It is an, we always praise judiciary, but also we have to acknowledge the effort made by the great counsels, advocates Nani Palkiwala and Shirwan. Is it not?
Yes, sir.
So that is one side. And law students, for example, in the medical college, we need patient to know the practicality. Doctors will help. Similarly, if academicians help students how to collect data to file public interest, something going mining activities, indiscriminate mining activities going on in slum, there are no facilities, no shelter, nothing. If law students collect beautiful data, if it is going to be examined and prepared in a very best way and give it to the advocate, that alumni, then they can do pro bono service, they can file PIL. And if judges take things very positively and pass necessary favorable order to the vulnerable sections of the society, we can do best for people who are in need. So, four wheel of chariot: law student, academician, lawyers and judges have to act collectively to help the general public. Of course, Karnataka State Legal Service Authority is really doing wonderful job, taking the help of advocates and academicians, including paralegal volunteers, students. That has to be continued, so that we can try our level best to make litigation free state.
Yes, sir.
Is it not? That is our object. That is the motto of any government.
Beautifully explained, sir.
Yes.
So, how would you assess the current approach of Indian law schools towards legal education and constitutional awareness, sir?
See, when it comes to law schools and law colleges, there are differences. You have different kinds of institutions. Law schools are there, then law colleges are there, and the law colleges which come under private universities are there. It depends. Now, many law colleges are affiliated to Karnataka State Law University. Many law colleges are affiliated to Karnataka State Law University. They are really doing wonderful job. When it comes to law schools, you have national law schools and all. Of course, they are also doing wonderful work. At the same time, they are very much concerned about contributing articles, interpretation and moot court competition and all. They are very good, and they are going so many prestigious. They are participate. They, of course, our students also participating in the prestigious moot court. But in addition to that, if law schools adapt to go to the rural mass, meeting village people, meeting the labor class, vulnerable sections of the society, they can understand the ground realities. It may be a student of law school or law college, whichever may be. Unless they understand the ground realities of the individual or whatever public, they cannot help general public. Simply if they are sound in theory without knowing practical things, I think the very object is going to be defeated. This
Yes,
is
sir.
my Observation. Yes.
Yeah, knowing the articles versus actually practically believing them and
Yes.
implementing them is a very different, big
Yeah.
difference.
Theory with practical experience will help everyone.
Yeah,
They can learn lot and also they can help citizens.
definitely, sir.
Yes.
Sir, do law schools adequately prepare students to address contemporary constitutional and social justice challenges?
Of course, see, we have our own curriculum. It may be in law school or one or other, it is more or less similar, where we train students such a way. For example, in when they come to final year, they have alternative dispute resolution simulation will be. Then we will be sending them for conducting survey, adapting some villages, and they also assist legal service authority. Recently, we have ours is a university law college, Bangalore city. We adapted some villages nearby, and we requested Kalsa. Our students have prepared a questionnaire where we collected details and we prepared a pie chart where how many do not have Aadhaar card, how many do not have labor cards. Then when we spoke to the member secretary, Shashidhar Shetty sir, he's really doing wonderful job. And immediately they telephoned to the district judge and they in turn informed all the officers. They were there and then and there only they resolved. So when we take our students to do all this exercise, they will also be learning some practical issue. Along with classroom, if they go to the outside the world, know all these things, then it will be, because many students do not know what is RTC, what is MR, what is EC, encumbrance certificate, they don't know. RTC, what does it mean? They don't know. Where MR copy available, they don't know. What is Akar Band, they don't know. What type of soil it is, whether it is dry land or wet land. That concept, simply if you just explain them in taking Karnataka Land Revenue Act and all, it may be good for examination for scoring. But if you want to learn practicality, one should get into all these aspects. Then only they will be prepared very effectively, both in practical as well as theoretical. Yes.
Definitely, sir.